with the next. No? So, tapos na yung Section 5. Section 6 is very simple. The liberty of abode and of changing the same within the limits prescribed by law shall not be impaired except upon lawful order of the court. Neither shall the right to travel be impaired except in the interest of national security, public safety, public health as may be provided for by law. Please take note. Liberty of abode, if you look at the words, okay, can only be impaired upon lawful order of the court. Right to travel can only be impaired based on public safety, public health, as may be provided by law. Okay? So, please take note of the difference in the wording. In Manotok versus CA, okay, a person charged with violation of the SRC and estafa, who is out on bail, claims that whole departure order should not be issued because he is already out on bail. Sabi niya, you can no longer impair my right to travel. May bail na nga meron na akong guarantee that I will be back there, I will appear there. Sabi ng Supreme Court, mali. Mali ka dyan. Okay? Mali ka dyan. Because precisely may bail ka. That means your bondsman is taking responsibility to make sure to bring you to court when the court requires him. If we allow you to go out of the country, the bondsman will be freed of responsibility. Kasi, hinayaan ka namin lumabas outside the jurisdiction of the court O, hindi na namin siya pwedeng sisihin. So, yung whole departure order, yung restriction sa yung right to travel, necessary yan para magkaroon ng sense yung bail. Okay? Kasi, kung hindi na namin makokontrol ang pagta-travel mo, walang silbi yung bail bond mo. Okay? In the case of Genuino versus De Lima, dito nakarma yung ibang mga tao. Hindi ko na sasabihin kung sino. Kasi nung panahon ni GMA class, ginawa nila yung mga watchlist order at saka yung, kasi class, ang whole departure order, pwede lang issue yan ng court. So nung panahon ni Gloria, yung DOJ nag-issue ng administrative order na pwede na sila maglabas ng watchlist order. Ano yung watchlist order? Same ang effect niyan. Same ang effect sa whole departure order. Pag nasa watchlist order ka, hindi ka makalabas. Okay? Anong difference? Yung isa, issued ng DOJ. Yung isa, issued ng court. Kasi, pag tinignan nyo Constitution, di ba? The right to travel can only be impaired by law. Okay? Or by a court order. So, sino nagbigay ng authority sa DOJ? Hindi naman, wala namang batas. Okay. In-implement yan ni GMA. Ironically, years later, nung si GMA na yung charge before the DOJ, tsaka si Genuino charged before the DOJ, nag-issue ang DOJ ng watchlist order against GMA. Consequence, hindi makabiyahe si GMA. At saka si Genuino, tsaka si Mikey Arroyo. So they went to court, questioning the very administrative order that was issued during their time. So, hindi ba nakakatawa? Nakakarama sila sa sarili ng katarantaduhan. Okay. And the Supreme Court agreed with them. Okay? Because under the law, the DOJ has no authority to impair the right to travel. Okay? Because malinaw yung sinabi nga, di ba? It can only be impaired by law based on national security, public safety, and public health. In this case, there is no law allowing the DOJ to stop, restrict, or impair the right to travel of one who is undergoing preliminary investigation. Therefore, the administrative order had no legal basis. Okay? It has no leg to stand on. So kahit na nakarma sila, tama din naman ang punto nila. No? In other words, nung inisyu pala nila yon, alam pala nila na unconstitutional yon. No? Sinabi lang nilang unconstitutional nung sila na ang tinamaan. Pero pwede naman, baka naman hindi rin nila alam. Okay? In the case of Silverio versus CA, eto, he wanted to interpret, kaya I said kanina, note the difference in formulation. Liberty of abode can only be impaired by an order of the court right to travel only by law. Parang ganun ang dating, di ba? Only by law. Di ba? Kasi sa liberty of abode, nabanggit yung court order. Sa right to travel, walang court order. Hence, ang assertion ni Silverio, hindi pwedeng mag-issue ng whole departure order ang court kasi under the Constitution, by law lang, not by court order. Okay? Can you follow? But the Supreme Court said that is a wrong interpretation. Why? Because once the court has jurisdiction, it necessarily has the power, okay, to enforce its decisions. Okay? Alangan naman meron siyang jurisdiction pero hindi niya pwedeng i-enforce. So sabi ng Supreme Court, to interpret Section 6 in a way that will deprive the court of the power to enforce its decisions is wrong. Okay? Because constitutionally, once the court is given jurisdiction, necessarily implied is it has the power to enforce its decision. Okay? Clear? Okay. Section 7. Right to information on matters of public concern. Okay? What is this? Well, as we have learned when we talked about freedom of speech, di ba? The essence of democracy is the free interplay of ideas. Di ba? Ang importante sa demokrasya, lahat tayo may participation sa pag-uusap ng ano ba tama at ano mali. Okay. Our right to participate in discussions will become useless if we have no information. Okay? So, that is why the Constitution guarantees that every citizen must have access to information on matters of public concern. Because, anong silbi ng ating freedom of speech? Anong silbi ng freedom of expression natin kung wala naman tayong information? Okay? Clear? So, in province of Cotabato versus GRPP's panel, okay, there was a memorandum of agreement about to be signed between the government and the MILF regarding ancestral domain lands. So Cotabato invoked the right to information on matters of public concern. Kaya sabi nila, malamang apektado kami niyan eh. Merong claimed ancestral lands dito sa Cotabato, but we don't even know what is that. We don't even know anong pipirma ninyo. Kami apektado dyan. So they demanded using the right to public information. Right to information on matters of public concern. The state, okay, claimed, no? The GRP claimed, no, wala kayong right to information kasi wala pang signed agreement. So it was claimed by the state that the right to information will only be available once the document has been, or the agreement has been consummated. Okay? Tama ba sila? Siyempre, sabi ng Supreme Court, gago ba kayo? And then they proceeded to explain. As I mentioned earlier, the reason is so that maging meaningful ang participation ng citizens sa debate and discussion. That is the reason behind the right. So, if that is the reason behind the right, it would be stupid. Sorry, lack of a better term. It would be stupid to assert that the right will only be available once the agreement is consummated. Okay? Kasi, by that time, citizens' participation in the discussion will be useless. Okay? The reason is so that the citizens can participate. So it cannot be available only at a time when their participation becomes useless and moot. And so sabi ng Supreme Court, that is a wrong argument. The right is there always, precisely so that the citizens can participate in discussions on matters of public concern. Okay? Request for SALN. Alam niyo naman ito. Diba? Nung panahon nung impeachment ni Corona, diba? Naging malaking issue yung SALN. So, ang dami nagre-request ng SALN ng mga justices. And I hope you would read this case because in this case, the Supreme Court considered the other side. Okay? Do you know the other side? When they assert that crazy argument that people will just take advantage of the SALN for political purposes and all that stuff. Diba? Yan yung sinasabi nila eh. Ayaw namin ibigay kasi gagamitin lang nila sa politika. Class. Precisely. Gagamitin talaga yan. Bakit? May public accountability ka eh. Okay? May public accountability ka. Unfortunately, the Supreme Court still considered, sige, may concern na ganyan. So dapat may proof ng good faith. It will be used for proper legal purposes, not for bad faith reasons, but for good faith. Okay. I don't necessarily agree with that, but okay. But in the end, the Supreme Court said, that while you may regulate, okay, the release of those SALN, the regulation cannot amount to a prohibition. It cannot amount to a deprivation because that is a right under the Constitution and that must be respected because that is important. It is important for our people to understand and to know, part of our right to information on matters of public concern. Okay? Section 8, the right of people, including those employed in the private sector, this is the right to association. Okay? We have a right to be part of an organization. Kasi there was a time class in panahon ng martial law na pinagbabawal yung mga organisasyon, we cannot even organize, we cannot join unions and all of that. So now it is a constitutional guaranteed right. We have a right to associate. Even government employees have now the right to form unions. They cannot strike, but they can form a union. Okay? That is now a guaranteed, constitutionally guaranteed right. In the case of Inre Edilion, isang pilosopong abogado said that if we have the right to associate, we also have a right not to associate. Okay? So sabi niya, so why am I as a lawyer being compelled to join the IBP? Worse, why am I being compelled to pay the fees? Okay? I have a right to association, therefore I have a right not to associate. And the Supreme Court said, tama. Eh di kung ayaw mo, wag. But the Supreme Court has the power to require as a precondition to practice law, membership in the IBP. It is a matter of police power and supervision. So, you have a right to associate and not to associate. Fine. But kami naman may power to regulate the practice of law. So kung ayaw mo sumali, that's your choice. Right? Hindi ka naman namin pinipilit eh. Pero pag hindi ka kasali, hindi ka pwede mag-practice ng law. Kasi importante yun sa pag-ensure ng competence and integrity in the practice of law.